Hello and welcome to the 2017 Hearing Officer Update. This update is sponsored by the Georgia Association of Educational Leaders with support from the Georgia Department of Education Policy Division. In order to participate in this training, the following conditions must be met. All persons participating in the video training update must have completed the basic 5-hour training course for hearing officers and tribunal members that was offered in 2016 in the early part of 2017. Individuals that have not completed the basic course should contact Jimmy Stokes at jstokes@gale.org to secure dates and times for the training. The 2017 basic training will be provided by Gale at both the summer and winter conference. That will be the winter conference of 2018 and through selected RESAs, and that training will take place during the fall. Credit for participation in this training will be provided through an affidavit that will be provided later in the presentation. Perhaps the most important concept with regard to conducting disciplinary hearings in schools in the state of Georgia is the application of due process. Due process is a three-legged stool and must consist of 3 parts, and they must be present in every hearing that we conduct. The first of these is the student and their families must be given adequate and timely notice with regards to what the student specifically has been charged with. I would ask again that when you write the charge letter that you reference the specific section from your code of conduct which relates to what the student is being charged with. The student and his parents and his lawyer or her lawyer, if they should have one, must have the opportunity to present and cross-examine evidence. We'll speak more about one of the evidence issues in just a moment. The third leg of due process is that the decision itself must be based on the evidence presented in the case. I want to remind everyone of the importance of not providing student disciplinary records, student grades, or student attendance until the student has been declared innocent or guilty. Of course, you wouldn't offer it if their student was found innocent. But once the student is found guilty, then it is proper to introduce grades, attendance, and discipline record, but not until that time. One of the problems that we continue to have is the use of student witness statements. Written student witness statements can be used in a hearing only if the student witness writing the statement is present to be cross-examined. Otherwise, you may not use the witness statement. Under federal evidence rules, administrators may testify and be cross-examined on interviews they have conducted with students or witnesses of any type who are not present at the hearing. Please be aware that if a lawyer is present in the hearing, they may ask to have that testimony stricken because they classify it as hearsay. But I want to remind you that you are an expert witness. Having been a school administrator for X number of years or for the amount of time that you have served, most certainly gives you the skill and the capability and the training necessary to receive student statements and to classify that which is good, which is bad, which is indifferent, and so forth. So you are an expert witness, and so therefore the testimony that you provide is not hearsay. And that comes under federal evidence rules, which Governor Nathan Deal put all student disciplinary hearings under in May of 2012. I'm happy to report to you that the 2017 General Assembly passed no legislation that directly impacts conducting student disciplinary hearings. However, educational leaders should be aware that legislation to limit placement in alternative school to 2 semesters was defeated on the last day of the session. We certainly expect to see that legislation appear again next year. But for the present time, we don't have any new legislation that we have to deal with in terms of the application of discipline. I do want to strongly suggest that hearing officers and tribunals seriously evaluate routine placement in alternative school that exceeds 2 semesters. Not saying don't do it. All I'm asking is that you seriously evaluate putting a student in alternative school for more than 2 semesters. Obviously, serious offenses and serious situations are exceptions to this suggestion. If a student has committed a heinous crime, you certainly can keep them in alternative school for a much longer period of time. But routinely placing students in alternative school for more than 2 semesters should be seriously evaluated by local school systems. One of the situations that we continue to have problems with is that of charging students with being chronic disciplinary students. I want to review this to make sure that everyone is doing it correctly. This is a state law, folks. This is 20-2-765, and we are all compelled to follow this law in dealing with chronic disciplinary students. Anytime a teacher or principal identifies a student as a chronic disciplinary problem student, the student shall notify by telephone call and by either certified mail or statutory overnight delivery with return receipt requested, or simply first-class mail, the student's parent or guardian of the disciplinary problem. Invite such parent or guardian to observe the student in a classroom situation and request at least one parent or guardian to attend a conference with the principal or the teacher and to devise a student and disciplinary and behavioral correction plan, sometimes referred to as behavior contract. Folks, we have to do all 3 of these things. We have to notify the parents, we have to invite them to come to a meeting, and we have to execute the disciplinary contract. It is required by Georgia law, and before we can charge a student with being a chronic disciplinary student, we must meet all 3 of those applications with regard to this law. There are some other code sections that you most certainly need to be aware of, and this has to do with the expulsion of students, particularly those students who are under the age of 16 and who are still under the compulsory attendance law. First, let's talk about 20-2-154.1. In that law, it says, it is the policy of this state that it is preferable to reassign disruptive students who are subject to mandatory attendance pursuant to Code Section 20-2-690, that's the compulsory attendance law, to an alternative education program rather than suspending for more than 10 days or expelling such students from school. Doesn't mean you can't do it, but this is the policy of the state is preferable to reassign those students to alternative school. If a local system does not intend to offer services to students who are under the age of 16 once they have been expelled from alternative school, I strongly advise that that school system initiate a local policy approved by the Board of Education that permits such expulsion without services being provided. 20-2-768 permits refusal or readmittance to students convicted or charged with a felony, and we will talk about that more in just a moment. But once again, if students who are under the age of 16, it is the policy of the state that it is preferable to assign them to alternative school rather than to expel them. If they are assigned to alternative school and then they are expelled from the alternative school, then the question of whether or not to provide services is a local option. And as I've said, I strongly recommend that you have a local policy which dictates how you're going to deal with those students who have been expelled from alternative school. I receive more calls from school systems about this one situation than most all others combined. This has to do with students who have been charged with or who have been convicted of felonies. Now, folks, this is the law, and if you have to notify parents with regard to a hearing regarding this matter, this is the law you cite, 20-2-768. Here's what the law says. Each local Board of Education is authorized to refuse to readmit or enroll any student who has been suspended or expelled of being convicted of, being adjudicated to have committed, been indicted for, or have information filed for the commission of any felony or delinquent act under Code Section 15-11-20H, which would be a felony if committed by an adult. So if you have a student that has been arrested, charged, or convicted of a felony, then the law is very specific. It says that you may refuse readmission or enrollment. The law says specifically if readmission or enrollment, the student or the parents or legal guardian have the right to request a hearing pursuant to these procedures. I strongly recommend that you go ahead and have the hearing. The suggestions that we have received is that once you hear that a student has been charged with a felony, is that you place them in alternative school until they are adjudicated. And then once they are adjudicated, and if they are found guilty of a felony, then you may deny them admission or readmission or re-enrollment. But I strongly encourage you to have the hearing with the parents prior to doing that. 20-2-768 further states, a hearing officer, tribunal panel, superintendent, or local board of education shall be authorized to place a student denied enrollment in a local school system under subsection A of this code in an alternative education system as appropriate and in the best interest of the student and the education of other students within the system. And this is what led to the recommendation that once you find out that the student has even been charged with a felony, that you have a hearing and place them in alternative school until they are adjudicated, and then you can make a decision about whether to keep them in alternative school or whether you want to deny them enrollment altogether. Just a reminder that 20-2-768 says it is the policy of this state that it is preferable to reassign disruptive students to alternative educational settings rather than suspend or expel such students from school. That's the law, but it certainly gives local systems the opportunity to do otherwise. The official code of Georgia 20-2-690.1 has to do with students and compulsory attendance. The requirements of this subsection shall apply to a child during the ages of mandatory attendance and is required as required in subsection A of this code, and who has been assigned by a local board of education or its delegate to attend an alternative public education program established by that local board of education. I want to emphasize again what the law says. It says nothing in this code shall be construed to require a local board of education or its delegate to assign a child to attend an alternative public education program rather than suspending or expelling the child. But I want to encourage you emphatically that you must and should hold a hearing prior to any such action. You may certainly deny student in re-enrollment based on the fact that they are a threat to the safety and security of the school, but please do so via a hearing in which you ask the principal of the school to testify that the readmission of this student would present a substantial threat to the safety and security of the school. We've had several questions with regard to the redaction of students in videos used in hearings. Most of the videos that are used in hearings come from either bus videos or security videos. The interpretation of the FERPA policies regarding the use of unredacted videos, that has everybody's face in it, in hearings has been inconsistent. Based on what is known at present, here is the guideline that we are asking folks to follow. Number one, if your system has the capability to redact students' bystanders' faces, that means you can put that foggy looking thing over their faces. If you can redact those from hearings, that's for bystanders, in which bus and security videos are used, then by all means you should use it. If your system does not have such capability, then videos may be used without redaction. I have provided for you the reference for the FERPA guidelines with regard with the use of videos. If you have any questions about it, I strongly encourage you to read this, but it once again is filled with lawyer type language, And if all else fails, refer to the two recommendations. If your system has the capability to redact the bystanders' faces, then do so. If you don't have the capability to do that, then carry on with the videos without redaction. We continue to have cases throughout the state regarding the use of telephones. Courts have continues to support the use of telephone evidence in the form of videos, text messages, emails, and social media. School administrators must refrain from indiscriminately searching student telephones for possible evidence. You cannot walk up to a student and say, "Hey, let me look at your phone. You might have some trash in there." You have to go looking for a specific thing. You have to tell the student what you're looking for. I strongly suggest that administrators ask the students to call up the appropriate area of the phone. Text messages, videos, pictures, whatever the case it is, whatever that you're looking for, that you ask them to call it up prior to the search. Once again, the law is very clear. Whatever you find during your search, you can use as evidence against the student. But you still are not given the opportunity to just randomly search a student's phone without some indication of cause. Please be aware that electronic copies, that's Xerox copies, of messages and photos which have been printed out are preferable for presentations and hearings. I strongly discourage you from bringing the telephone to the hearing and trying to show the messages from the actual phone. Having the pictures and the electronic copies is much better in terms of the overall presentation of evidence. I need to remind everyone, school administrators are not authorized to permanently confiscate student telephones or personal property. You most certainly can hold them until the parents come and pick them up or for a specific period of time, but you may not permanently confiscate student property without a warrant. So, and you're not going to get a warrant for that, so just don't confiscate student property. State Department asked us to review with you several pieces of Georgia code which are important to our work in discipline. The first of these is 20-2-155. If you have to refer to any of these, just Google them and it'll come right up for you. 20-2-155 requires that every school have a code of behavior and a code of discipline and a student handbook. If you are concerned about the requirements that must be met with regard to the handbook, please feel free to get in touch with me and I'll send you another copy of the requirements of student behavior which must be included in the student handbook. But 20-2-155 is the law which requires that. 20-2-735 simply requires that boards of education adopt policies to improve the student learning environment, and that includes the handbook. This is the section of the law that requires that we have a student handbook and it be provided to the student each year. 20-2-741 is the law which requires that every local board of education is required to send copies of their student disciplinary policies and their handbooks to the Georgia Department of Education. They don't require the handbooks as such, but they do require the local board of education school discipline policies. 20-14-33 is the Education Accountability Assessment. This is the part of the law that requires that your discipline data be used in the calculation of the Student Climate Index, which is a part of CCRPI. Folks, if you have questions with regard to discipline or with regard to the conduct of hearings, please do not hesitate to call me. My number is 770-601-3798. You can email me at jstokes@gale.org. There is no charge for the service. I'll be glad to help you in any way that I possibly can. But again, if you have questions, if you have situations that you need to discuss with someone, do not hesitate to call me at 770-601-3798. In order for you to receive credit for the hearing officer update, tribunal update for this year, please send an email to jstokes@gale.org, and please affirm in that email that you have watched the hearing officer update presentation. Once you have done that, I will respond to you and indicate that you have met the requirements for training for this year. Thank you very much for your participation in this event sponsored by the Georgia Association of Educational Leaders with support from the Georgia Department of Education Policy Division. Thank you.